Hi, a very good afternoon to all of you all. Let me tell you the plan for today. So basically, for your SBILL paper, I will be helping you to cover your 40 marks out here. So this is 40 marks and the balance part is your 60 marks. Okay, so setting up is your 60 marks. Now, how do you start one day before the exam? So remember one thing, that complete your part A first. Complete your part A first. In case you haven't done that, you start your part A now. Okay, start completing, knocking it off. I have given you all access in the dream batch. Start completing your entire part A first. Second, you have to keep reserve approximately 5 hours for part B. Okay, whether it is the last few hours of your examination or anything, approximately 5 to 6 hours should be kept for your part B. So I am helping you cover your part B. Okay, all your entire things, all the access of all the lectures are there in the dream batch. You can go ahead and start knocking off chapters in case if you don't know. Now remember one thing, that in your part B I will be covering everything, so nothing majorly should come outside than what we do. Okay, so complete your part A, or maybe if you want to complete simultaneously, as and when I'm doing one chapter, you can revise one chapter of part A, start knocking it off. But 6 hours, 5 to 6 hours is what you should give for part B. Rest all you should give for your part A, so you're good for exams. Okay, so how much ever you can complete, 40 marks is going to be covered from your last few hours. Also you should study this particular part B. Start with part B, so it becomes easy for you. Out of 40 you can easily pull off 30. Then in part A obviously you will get few more marks also, so 50 marks is manageable that way. So you should try to get 30 marks in part B, so that 10 to 20 marks even you can easily pull off in your part A. Okay, so this, it is up to you. My suggestion is keep 5 to 6 hours whenever you want. Rest you can do your part A. Either you do it with me now, and in between whenever I give you a small break, you can cover your part A chapters. Okay, so without further ado, let's finish your part B. So first I will be covering one entire chapter which is called as your POSH Act. Okay, the first chapter that I will be covering is out here. Okay, so good to go. Am I audible, visible, AV in the chat box, so I can quickly start and complete it? Okay, I just require AV in the chat box. You mention it, I will cover this chapter in 20 minutes for you. Okay, in 20 minutes. You sit with me, cover the chapter, then go to part A simultaneously, up to you. I want AV in the chat box, audible, visible, so I will start and complete this chapter for you. Quickly. Okay, just waiting for your response. Waiting for you all to put in the chat box. Great. Okay, chalo, let's begin. Hi, so we start with your chapter called as the POSH Act. Sir, what is POSH? It is Prevention of Sexual Harassment in Workplaces. The act, the name of the act is Sexual Harassment of Women at Workplaces. What government wants to do? They want to prevent, prohibit, and if there is a sexual harassment, then they want to redress it, solve the thing. For this they made a proper act. Proper institutions has been made where any woman feels that there is a sexual harassment in a workplace, where they can go to complain and how much time the results will come, etc. Now before we come, in all your labor laws, I want you to learn the object of the act for all the labor laws. So whenever you start any answer, it is always advisable to write the introduction and the object of the act. Okay, and then we will start with the real provision. So what is the object of the act? So the object of the act is obviously to prevent and prohibit and provide redressal to women who have faced sexual harassment. But we will write that it is a act which has been introduced to fulfill the articles of the Constitution. So the act has been made because fundamental rights of women are violated when they are sexually harassed. Okay, so fundamental rights are of your article 14, 15 and 21. So we know 14 is right to equality. So men are not being harassed, only women are being harassed. So it's a right to equality which is violated. Next is article number 15. What does article number 15 talk about? It says that discrimination is there on the basis of gender. Okay, so women can face discrimination in terms of employment, in terms of promotion, in case of or any other kind of pressure that they face in the work environment. So article 15 is about prohibition of discrimination again on the basis of gender, and this is a right to life gets violated. Sir, what is the object of the act? I have told you to, in every single labor law you should write the object of the act. So the object is to protect women against sexual harassment from workplaces. So beautifully we can write it, and in case if that happens, then there should be an effective mechanism for redressal of the complaints, for solving the complaints. Okay, so few of the objects we can write from the name of the act only: protect, prevent, redressal, constitutional right. Beautifully. So what happens is the right to dignified work, so they can work in a dignified manner. Not only that, this is in line with the international standards given in your convention on elimination of all forms of discrimination against women. So there was a convention which is saying that elimination of all forms of discrimination against women should be done, which India has also signed. So pursuant to that we passed this law. So okay, so we have these points that we can say: protection, prevention, redressal, constitutional rights, international standards or convention that we have signed. All this we will write in the object of the act. Okay, now also we have to write that this act has also come before the act. Now see, if you go to see the act was passed in which year? It was passed in 2013. Okay, however, before 2013 also there were some guiding principles which came on basis of the Vishaka judgment. It came in 1997. So Vishaka versus State of Rajasthan, there was a case where Rajasthan court laid down, Supreme Court actually laid down that how women should be protected in workplaces. Okay, so they had told that proper mechanism should be made by employers to prevent them from harassment in workplaces. Okay, pursuant to that, post the Vishaka judgment, this act was passed. This line you can write. Okay, now in this act, obviously, who will be the complainant according to you? Men or women? Obviously, the women will be the complainant here. So how do I define an aggrieved woman? Aggrieved woman means any woman, any lady who has been subjected to any kind of sexual harassment is called as an aggrieved person. Okay, and in relation to any dwelling place or a house, a woman who is employed in such dwelling place or house. So even in the house also, if any house help or any maid or any other person working in the house, any lady faces sexual harassment, this act will cover that also. Okay, now employee. Now when they say employee means what? Now any employee workplace, so in workplace there will be an employer who has employed an employee who has been employed. So in employee they are covering all kind of employees. Okay, whether you're part-time, full-time, whether you're co-worker, contract worker, trainee, intern, all the forms of employees are covered. Okay, so it is whether you have hired directly or you hired through an agent, with or without the knowledge of the principal employer, means the scope is wide. Anyone working for the company, whether the main employer knows or doesn't know. So maybe if the employer has hired a contractor and the contractor employees has been harassed, still they can come because they are working for the company. Simple. So the act has been kept broad, so everybody will be coming in. Now very important is sexual harassment definition also has been widened, which is important. Okay, that means how do you define sexual harassment? So sexual harassment has been defined as any unwelcome act or behavior. So it is an act or a behavior where there is the worst form, the biggest, most serious is a physical contact. Okay, actually someone has held a hand, okay, or someone has harassed, that is a physical contact. Second is there is no physical contact, but there has been a demand for sexual favors, maybe on basis of which promotion will be given, or if that is not given, then demotion will be given. So either either a positive thing will happen to you, or a negative thing has happened to you if the person has not met the demand. We will see. So either a promotion or a demotion. So basis to that is also a sexual harassment. Any kind of remarks, colored remarks, or even there was a case where the employer called the employee sweet. You're a very sweet person. Now that also can lead to harassment. Okay, or showing any kind of pornography or any other unwelcome physical, verbal or non-verbal sexual gesture. So everything has been covered, that even physical, verbal, oral or non-verbal, even actions have been covered. So even gestures have been covered under the definition of sexual harassment. Okay, so this is important, they can ask you. Now, they have categorized sexual harassment in two categories. So they have bottled down, and normally when they have studied sexual harassment at a workplace, they have seen two kinds of things. One is quid pro quo and the other one is a hostile environment. So quid pro quo means what? Something in return. If one is not adhering to the demand, either you will get a positive thing or you will get a negative thing. Either if the boss is asking the employee to advance any sexual advances, on basis of which promotion will be done or demotion will be done. So that's quid pro quo. Second is just having a hostile environment, a work environment which is very toxic. Okay, where a person feels unsafe is also covered. Okay, so here even an environment surrounding which is toxic, which is having a lot of pressure, is also covered. Let's see. Two forms of sexual harassment. Most common ones are quid pro quo. That means a promise for something good, preferential treatment will be given, or a detrimental treatment will be given. Okay, if it has not been adhered, if the particular person has not agreed. Okay, hostile environment, hostile work environment means what? It's a culture, it's a work environment or the work surroundings. If a person is being humiliated oftenly, so that also can lead to harassment, because it is leading to harassment, right? Trauma, if somebody has insulted you, etc., that also can come. That is with respect to environment. Quid pro quo means what? A positive or negative thing. Okay, now they say that what is a workplace? For the purpose of the act, the term workplace has a wide definition. Normally, it would mean a person working in the company office is a workplace, the area. However, if someone has gone to the client's office and in the client's office they face, still it will be covered. So there is an extension of work will also be allowed. If there is a work from home and on that you have faced any harassment, maybe through a video call, etc., but you were working and you were at home, so the distance, or maybe there was an example of harassment faced in a mess, that is a canteen. Mess means what? Canteen. So that is also covered. So any place visited by the employee, okay, in course of employment. So any place, if an employee has gone to the canteen, covered, has gone to the guest house, covered, has gone to the client place, covered. Okay, this includes guest house, hotel, they've gone in another state, or a client's place. Everything has been covered. So workplace definition I have told you, it's a wide range which covers anything which in relation to the work the employee has traveled. Okay, then comes prevention of sexual harassment. So very simple. Section 3. Now we just seeing till now we were just understanding the definitions, object of the act, etc. Section number 3 is what you have to quote no matter what question comes from this act. So no matter what question has come from this act, You will write the introduction, you will write the object, and you will also write section 3. So what is section 3? Why is it so important? It is a prohibition that no women shall be subjected to harassment in a workplace. So this is a very nice common general line, common restriction given. Okay. The following circumstances occur in relation to a connected person. Behavior may amount to sexual harassment. So the following things following circumstances, and this we've covered above. Yes, quid pro quo, there were 2 points. Either promising a preferential treatment or a threat of a detrimental treatment. Both we had covered, is also covered. Then one more was there, which was the second point, hostile environment. So even if you go to see, in the hostile work environment is also covered. Okay, a threat is also covered, and anything which is likely to cause the safety of the person, that is also covered. Clear? Now, so section 3 is everyone has to write that. Now comes the most important, that if a woman, we saw this act is not about only prohibition, that we saw section number 3 saying prohibition. But if a person has faced sexual harassment, then what the government has done for prevention, what they have done, and for your redressal, what they have done. So actually the act has made 2 things. They have made a internal complaint committee and a local complaints committee. Very important. This you have to understand the entire crux of the act. It says that the internal committee, internal means what? It will be set up. It has to be set up by employer. And in this there will be a senior woman person who will be there in the committee. Maybe an employee or maybe a person from an NGO, etc. A senior lady will be there in this internal committee. Any women who in a workplace who has faced sexual harassment will write to the internal committee that listen, I have faced this sexual harassment, this is the issue, etc. Okay, so this is set up by the employer only. Second, even at the state level, okay, even the government at various district level. District means at every level they will make a local complaint committee, or the local level they will make so this complaint committee is made by government. So if a employer has not made the internal committee, or the internal committee is not listening to you, then the person also has a right to go to the local complaints committee, which is set up by the government. Concept clear? So for the employee, the first point of redressal is your internal complaints committee. Okay, let's see. So internal complaints committee, very, very important. Write in the next section. So no matter what, you will write section number 3. Then you also say about the main thing, the mandatory constitution of internal complaint committee by the employer. Okay. Section 4 also we can write mandatory constitution of internal complaints committee. Section 4 says that every employer of a workplace shall, by order in writing, constitute a committee known as internal complaint committee. So section 3 done. Who will be there in this committee? I told you, one senior employee, women employee will be there. Okay, from any of the administration unit or organization. 2 other members committed for cause of work in social work, etc., who have maybe worked in an NGO, etc. Okay, committed to cause of women. So any 2 other females who are there, who are wanting to help women. And third is one member from an NGO will also come relating to sexual harassment. So this is a composition. Now, then this is the internal complaints committee. Then comes the local committee. What is the local committee? It is set up by whom? Employer or government? Obviously, I told you the government is required to set up a local complaints committee. And why would they do? Same job, to investigate and redress the complaints of sexual harassment from maybe unorganized sector, because in unorganized sector employer must have not made only this committee. So for them also it is there, or in any place where it has not been constituted by establishment having less than 10 employees. If it is, or if the complaint is against the employer only. So it is made to redress complaints from unorganized sector, which is not organized, doesn't have a system, etc. Normally, where there are less than 10 employees, employer is not required to make this internal complaints committee. Third is if the complaint is against the employer only. And fourth, if the ICC has not been constituted. So just very simple little point that ICC is not there or is not working, or you want to complain against the employer only. In all these cases, anyone can go to the LCC, Local Complaints Committee. Simple. Now, very important is, this is important. Okay, this is important. Now we did section 3, we did section 4, and now comes an important section, which is section number 9. So what is section 9? It's the process of the filing. It's very simple, and a complaint will be made. We'll see. Okay, the complaint will first be filed with whom? So what is this about? Process of filing a sexual harassment complaint. So this process is important enough for us to know. So what are they saying? That any aggrieved woman may make in writing a complaint of sexual harassment to the internals committee within a period of 3 months from the date of the incident. So very important. Within 3 months from the date of the incident, she will complain to the internals complaints committee. Okay. Now 9 is over. What was 9? That woman complains in 3 months to the internals complaint committee. So any aggrieved woman can complain to the internal committee within 3 months from the date of the incident. 10 says that when a complaint has been made, they will see that if they can, before starting the detailed inquiry, if it is not very serious complaints, then whether they can settle it through conciliation, through negotiations, through talks, can be completed, but monetary settlement should not be the basis of conciliation. Means you cannot give the women money and stop it. So maybe if the person has apologized, has said that I will not do it again, and the woman is satisfied, so that is also sufficient. That is called as a conciliation or a settlement agreed between the person. So he has apologized and he said he will not do it again. So that will always be the first measure that the internal committee should or will try. Okay. Where the settlement has been arrived, such shall be recorded, and arrived will be forwarded to the district officer also, that we have arrived. The internal or the local committee shall provide the copies of the settlement agreement to the aggrieved woman also. Where a settlement is arrived, no further inquiry will be conducted by the internal or the local committee. Simple. So first step, in 9 you make the complaint, in 10 they try to settle it through conciliation. If it is settled, it is fine. Okay, but monetary this cannot be done. And now let's say if it is a serious complaint and it couldn't be solved through conciliation, then there is a website also, shebox.nic.in. Okay, complaints management system. This is the online website to go and complain. And here if you go to see, very clearly it's written register your complaint. So you register your complaint and you also get a complaint number which you can track. Now, if it could not be settled through conciliation under section 10, then a detailed inquiry will be conducted. Okay, and detailed inquiry will be conducted where the internal committee or the local committee who is taking the complaint, whether respondent is an employee, proceed to make an complaint. If prima facie case exists, if they feel that yes, there is something wrong that is happening and could not be settled through conciliation, then they will, if they feel, they can also forward it to the police within 7 days of registering the case under the criminal laws. Okay. Now, once they do, they will give an opportunity being heard to the accused also, and the internal and this committee, both these committee will have all the powers of a civil court 1908 for summoning, for this and passing any orders. And very important, the inquiry shall be completed within a span of 90 days. So in 3 months she makes a complaint, right, and within 90 days the matter also gets settled. This is done. Okay, so what happens in 3 months? The inquiry is completed. So inquiry is completed. Then after the inquiry, what will happen? We'll see. Actions during the pendency of the inquiry. Okay, let's say if the inquiry is pending, then what to do of the man and the woman? So during the pendency of the inquiry, the employer can tell to the woman that we are going to transfer you to a safer department, okay, or we'll transfer the other guy to the other department, or we'll grant paid leaves to the woman. Okay, so the first is inquiry will be conducted in 90 days. During pending inquiry also we can transfer their departments and give the person paid leaves to work from home also, or grant such other relief that may be given. This is till the pendency of the inquiry, because inquiry is taking how much time? Inquiry shall be completed in 90 days. During 90 days, what to do? 3 months. So then they said that let them go or shift their departments or shift them into another office. Then the report will be prepared within a span of 10 days from completion of the inquiry. So the officer who is appointed will prepare a report and give his findings. Now remember these months. 3 months, within 3 months of the date of the incident, it should be complained. In 90 days, the inquiry will be completed, and in 10 days, within 10 days from the date of the inquiry, a report will be prepared. So the report will be prepared. Okay, this is the inquiry will be completed. Inquiry will be completed. And last, within 3 months, the complaint should be filed. Complaint should be filed. Clear? So all the 3 timelines should be clear, and it's very easy. Within 3 months you file a complaint, within 90 days the inquiry will be done, and once the inquiry is done, the report will be made in next 10 days. Okay, and then after the committee has found that the allegation against the respondent has been proved. Okay, so 2 things are there. If imagine the allegations were false or it was not proved, so 2 things can happen. Okay, so he was innocent, the man was innocent, or he was guilty. Okay, so 2 cases. After in the report, if it arrives to the conclusion that the allegation against the respondent has not been proved, then you will say no further action should be taken. But if in the other thing, the allegation has been proved and he is proved guilty, then they will take action for sexual harassment. They can deduct certain amount from his salary. Okay, and punishments can be given of different forms. Punishment provisions have been given under section 14. Now pay attention to this, that if someone files a false complaint, if a lady has misused this thing just to harass someone, then in that case, if it is proved that the complaint is malicious, or it's a false complaint, or they have false or misleading documents. So if you had seen Amber Heard versus your Johnny Depp online, if you see Johnny Depp versus Amber Heard, it was proved that Amber Heard was false, her allegations were false against Johnny Depp, and Johnny Depp won the case. So if at all the jury or the judge or the committee finds in the report that the complaint has been malicious, or it is a false complaint, or it is has forged or misled the documents, then we can even take action against the complainant. Even action can be taken against the complainants for filing. The lady, they can file for giving a false complaint. Clarification on false complaint: mere inability to prove a case will not mean that they have action will be taken. Just because they couldn't prove their case doesn't mean that it's a fake case. Fake case means it is mens rea is there, it has been evidence has been tampered, all those things are involved. Okay, establishing a malicious intent is needed to take action against the woman for filing a false case. Okay, now a prohibition of making, now this is a confidentiality provision. Okay, section 16, that nobody can not in RTI also you cannot ask the information. So nothing contained in section in RTI Act means RTN Act will not be applicable. The identity and the address of the aggrieved woman, okay, shall not be published or shall not be made known to public in or to the media in any manner. They've also made in section number 18 appeal provision. So within, if any person is aggrieved with the report or the decision of the any of the committees, then they can go in appeal to the appellate authority. They just said that appellate authority will be made to the court or wherever the appropriate appellate authority will be made within 90 days from the race of receiving the order. Okay. Now comes responsibilities of every single employer. What do you think is the responsibility of the employer? Is to having a safe work environment, is to set up the internal committee, is to participate, or is to permit your the investigation. What is the other responsibilities? Is to have a proper code of policy, to have a proper training of the employees. Okay, so having a good work culture, work environment should be there. Okay, so duties of the employer: every employer shall provide a safe working environment, display the entire penal provisions of the sexual harassment. Nowadays what companies are doing as a responsibility, they are giving POSH training to all their employees. So this is what they are saying, that awareness programs will be made, committees will be set up, okay, assistance in attendance will be given. Okay, if any employer if anyone wants to come, they will give support, etc. So assistance will be given in securing the attendance of anyone. Information sharing, so any information, CCTV camera footage which the employer has, they have to give it to the committee. They have to give legal support. They can initiate legal action against the accused. Treating as misconduct, sexual harassment should be treated as a misconduct in the company's rules, service rules only. It should be mentioned that this is a misconduct, action will be taken and monitoring should be done. Now committee to submit an annual report. Now the committee which is there, whether it be the internal committee or the local committee, in every year they will prepare an annual report, give it to the employer and the district officer. So the committee has a responsibility for every year to submit an annual report to not only the employer but also the district officer, who will further submit it to the central government, so that we know that what all is going on in the district, any complaints, etc. will be heard. Penal provisions have been given, you can read up. Okay, and that is it. We have completed the entire chapter, including all the past exam questions. Thank you. Okay, clear. So we've completed the chapter. Let me know in the chat box whether it was clear, yes or no. If it is clear, write clear in the chat box. I'll move ahead to the next chapter. I want you all to write clear in the chat box so I can start with my next chapter. Now I'm looking at which next chapter should I pick up and knock off. Okay, let's see. Okay, great. Everyone's writing clear. Okay, so lesson number 18 next I will knock off in reverse order. We'll go to lesson number 18. Okay, lesson number 18. Going to lesson 18. Now in lesson 18 also, chapter is very simple. Some are really small. So Equal Remuneration Act is extremely small. Okay, let's start with this. So this is your lesson 18. Lesson 18. So even if you take a book and pen and note down all the provision, you can build your own answer. Okay, So doing it with me, that is the best part. You can take a book pen, write down the keywords, and obviously then once you have the keywords, you can build your own answer also. Okay, let's start. Hi, so we start with your lesson number 18, one part which is called as your Equal Remuneration Act. This comes under the topic of law of wages. So it's about wages, payment, etc. Now, this act is about giving men and women, the entire law is about giving both men and women, okay, equal pay for work of same or similar nature. So it's basically giving equal pay for equal work. Okay, there should not be any discrimination on the grounds of gender is what the act is saying. So first, whenever any labor law comes, we will always write an introduction. In the introduction, we will introduction and the object of the act. Article 39 says that the state shall direct its policy towards securing. So this it's a directive principle of state policy, article number 39, which is saying that it's the duty of the state to ensure that their policies are made so that equal pay is given for equal work for both men and women. Simple. So to give effect to this constitutional provision, Parliament has enacted the Equal Remuneration Act 1976. What is the object of the act? So the object of the act is to pay equal remuneration for the same work or similar nature. It prevents discrimination on the grounds of gender, etc. Now the discrimination is prevented at the time of work, at the time of employment, and even during the time of employment. So for example, it prevents discrimination while recruitment and even after recruitment. So basically, while recruitment, in the offer letter, in the onboarding process, if that is disallowed, even after a person has been appointed, then for promotion work inside, now you are already in an employee, then promotional work, then no discrimination should be done by changing the work environment, giving unfavorable work environments within the job. So protect at the time of hiring and at the time when you are hired also. Okay, after recruitment, before recruitment. So just remember, no discrimination okay, before or after recruitment. Okay, simple little this, and this act applies to all the categories of work. Okay, all the categories of employment in India. Okay, now when they say remuneration, means in all the acts, in all the labor laws, they have the same thing. Remuneration means salary, DA, dearness allowance means what? Dearness, salary is given. In addition to that, for meet the inflation, DA is given. So, or any kind of cash benefit, any benefits if you're giving to men, then and you should also give it to women if it is the same work or similar work. Now, section number 3. Now remember the section number 3 of this act. It says that this is the most this, if you see, it has the biggest impact from preventing discrimination. It says that what if any woman has agreed to the discrimination, any lady must have agreed or signed a contract. So imagine there is a contract or agreement which she has signed to agree to the discrimination. For example, there was a discriminatory provision and she has agreed. She didn't know that men are giving more pay. She thought that this is the main pay. So what happens is, law says that even if notwithstanding contained under any law or any agreement or any other thing, no act, so it does not matter. So it doesn't matter what has been stated in any clause, agreement, contract. No discrimination should be done on the basis of gender. Finish. Overriding effect, that the act has a overriding effect over all agreements, contracts, etc. that has been entered. Means the employer has to, because see, I will not know what others are being given, na. If I am being employed and I am getting, let's say, 35,000, and someone else, I don't know other people's pay, so how will I say? So it is to the employer that it doesn't matter even if you make them sign, but you are doing discrimination, it is wrong. So section number 3 says it will have a overriding effect over any kind of contract, arrangement, award, any agreement or document. So ultimately section number 4 is the real law. It is a duty of the employer to pay equal remuneration to both men and women for work of same or similar nature. So no employer shall pay to any worker a rate less favorable than what he pays to the other gender. Simple. And section number 5 says that you cannot do it while recruitment, also no discrimination. And section number 7 says, 5 and 6 says at the time of recruitment or even later, or changing the subsequent to hiring, also no discrimination should be done. Then we see a simple little point, the authority will be set up, registers will be maintained, and penal provisions have been given if unequal rates have been given for the same work. Okay, with this we have completed the entire chapter, and women should never agree to unequal work for the same nature or same work. That is it. We are done with the chapter or the first part of the chapter. Now let's get into the second part, which is called as the Minimum Wages Act. Now we are doing the Minimum Wages Act. Okay, the second law that we are doing in your law of this is Minimum Wages Act. Okay, so what are we doing? We are doing lesson 18 part 2. We are doing lesson 18 part 2. So let's start. So we start with the Minimum Wages Act 1948. Now again, any labor law that comes in, we have to write the object or the introduction. In the introduction, we'll say that this act has been provided to give them minimum wages to the employees. So this prevents exploitation. Okay. Now who will set the minimum wages? It will be the government. Now they don't say the word government ever. They always use the word appropriate government. Always in labor law, since it is a labor laws comes under concurrent list, means in central government can also make laws and state government can also make laws. So whenever they say appropriate government, they mean that either it is the central government or the state government, whoever is making the law. So they don't say appropriate means whichever government is making the law, they will ensure that minimum wages has been given. Now it prescribes certain minimum rates for different scheduled industries. So in the schedule they've given you few industries, for them minimum wages will be set. Okay. Now if we just understand, it's the Minimum Wages Act, right? So what do you mean by the term minimum wages? What is the meaning of the term minimum wages? So minimum wages means the minimum wage that an employer should pay to the worker, and this is the lowest limit below which no employer can pay, and if he cannot pay the minimum wage, the business should shut down. So that's the lowest limit. What do you call minimum wage? You can call it as the lowest limit below which no worker should be paid. Okay, and I told you, always in or across or labor laws, when they say appropriate government, they mean either the central government or the state government. Okay, let's see. Now minimum wages. Now minimum wages, if you go to see that, you think the government must have fixed one single minimum wage? Now obviously there are different kinds of classes of work. For different classes of work, people are hired differently. Normally you might always think salary, you might always think of time work, but you might think of salary. But imagine in a laborer, sometimes they are paid per hour, but sometimes the payment sometimes in business happens per hour basis, sometimes it happens piece basis, piece work. Okay, for completing one project you must be having a payment. Then second is guaranteed time rate or overtime rate, like, so for all this the government will set up a time. Now guaranteed time rate means government will guarantee this much time has to be given, which will be at so this you don't have to get into depth, but just remember the minimum wages can be fixed for the time, for the piece, guaranteed time rate or overtime rate. So manner of fixing, how they will fix for all the different types, time, piece, overtime will be fixed. And section 3 subsection 3 says that for different classes of work, means for different industries different rates will be given. So the rates can be different for different employments, different classes of work. It can also be different for if it is an adult, it is an adolescent. Adolescent means who are above 14 but below 18. Children, apprentice, etc. for different locality. Now if you go to see company secretaries, maybe in or any salary in metro cities will be more, in non-metro cities will be much less. Okay, so all of that factors can be done to fix the minimum wage. Okay, now this minimum wage which has been done is revised time to time at a term not exceeding 5 years. Means within 5 years government has to revisit, because of inflation etc. this rate would not be sufficient, so they will keep revisiting this work. Now this they have asked in the past exam questions, section number 5. Okay, procedure for fixing the minimum wage. How will the government fix the wage? So ideally the government will decide for this for this schedule, let me put this amount. Okay, this directly they will say, but this doesn't happen because government doesn't have expertise. They normally hire a committee, they normally hire an expert committee who will prepare a research report, give it to the government that for this schedule we should have this pay, etc. So this is the most common method, which is a committee method. Committee method is the most this. But if the government says, no, I don't want to listen to any committee, I will notify directly. So then notification method is directly government will notify in the newspapers. So maybe it is possible that committee method must have given me initially. Now when I am revising, government can just put a 10% hike and notify it directly. So how the minimum wages can be fixed? First, appoint a committee, get their recommendation, then notify. Appropriate government may appoint some committees to hold inquiries and advise them with respect to fixation or revision of work. Simple. After considering the advice, they will fix the minimum rates. Now remember one thing, that this advice is advisory only. It is not, the government is not bound to accept this thing. It's an advice that we are asking from the committee. The committee's decision is not binding on the government. Notification method is government does not require a committee. They will directly publish the proposal, okay, and give a date of not less than 2 months before the date of the notification. Means at least they will put it out in the notification for public opinions and take proposals from the people directly, and then they will make it effective. So people who are affected can make their representation, etc. So they will say that we are having this we are notifying it and it will have effect after 2 months. Okay, means at least 2 months notification will be given, that the effective date will be after 2 months, so that people can within 2 months give their representation to the government. Now come to the next thing is minimum wage, whether it is paid in cash or kind. Now you tell me, normally you will always say, sir, it should be paid. Cash means what? Cash, your cash or kind means what? Cash means hard cash or electronic mode or checks or any other way, and kind means I'm not giving you money. Instead I'm giving you provision to stay, I'm giving you food, I'm giving you travel expenses. So kind, I'm giving you a gift. So that is kind. So obviously they will say that minimum wages shall be paid only in cash. But it's an old act where it has been a custom to pay partly in kind also, then appropriate government may accept it. Okay, certain kind, etc. With this, we have completed the Minimum Wages Act. Thank you. Now we'll go to the next act, okay, which is there. We go to the next act, which is your payment of wages. We finished. Let's go to Payment of Wages Act. Now we'll go to Payment of Wages Act. Now we're doing Payment of Wages Act. Okay. Now let's understand what is the meaning of the term Payment of Wages Act. Now this we did minimum wages. Now we are seeing Payment of Wages Act. Okay. For every act, remember, okay, this is also your lesson 18, part 3 we are doing. Part 3 means there are 4 acts, but part 3 of the act we are doing. So Payment of Wages Act. Very, very simple. Let's see. So the Payment of Wages Act 1936, okay, is a central law, means the central government has made the law. And what is the object of this act? That you should pay the wages to the employees. It's pretty simple, na? That you will pay the wages. But while making the payment, don't make unauthorized deduction. For example, I am paying the wage to someone. I say, listen, you had come late, na, 5,000 cut. Listen, you had done that mistake, na, 2,000 cut. Listen, you had I had told you to wear proper formal clothes, you didn't wear, na, 2,000 cut. So what is happening is we are making the payment but with unauthorized deductions. So it goes in the hand of the person is very less. So that is not allowed. That it should first of all be without unauthorized deductions and without unnecessary delay. So we should give it this provides, it regulates the payment of wages, that they get it on time and they get it the entire money they get without unauthorized deduction. So 2 important lines you have to remember is without payment of wages you do pay the wages, but on time and without unauthorized deduction. Very simple, sir. Understood. So remember, when they say on time means what? So they will say that moment the month is over, within 10 days you have to pay it to them. So we will see that timeline has been given. Okay. Now scope and object of the act. So this act also covers. Okay. Now let me see if a person is a CEO of the company. Do you think this act will be applicable on them? We are not here to protect all the top level employees. We are here to protect an employee whose wage is not exceeding 18,000 a month. Means they don't have lot of money. Okay, it's a very entry level salary. The main objective of any act is to eliminate all malpractices, all wrongdoings, okay, with respect to payment of wages, securing that the workers are paid their wages at regular intervals and without unauthorized deductions. So the job of this act, or the object of this act, is to ensure that the workmen who are earning up to 18,000, because it's like very little, they have to pay their electricity bill, they have to pay so many things. So you should pay them at a proper time period and without unauthorized deduction. Very, very simple. Now when they say wages means what, I have to pay the wages. I told you wages across all the labor laws is the same. It not only the basic salary but the DA, any kind of emoluments, any kind of allowance, all the other things are included and includes every single thing, traveling allowance, etc. Now we come to the main core provision of the act. Okay, section number 3, responsibility for payment of wages. So first, you have to pay the wages. Sir, who will pay the wage? Section number 3 says it is the duty of every employer, okay, who has employed workmen to pay wages. So it is the responsibility of every employer to pay wages to all the persons as per the law. Now this is very obvious, but we need to have this law, a written law. That is why this act is there. Now, okay, now section number 48 of 4 says fixation of the wage period, that every employer shall fix a wage period. So they will say that when you will pay the payment. Is it daily? Is it monthly? Is it bi-monthly? Is it quarterly? Is it half yearly? Is it after one year I'll pay you? So they say, listen, you can fix your wage period as you want, that I'll pay you in this time. So I want to pay a person every 2 months. Not allowed. What law says that the maximum wage period will be 1 month. Means never will you see a salary being paid for 2 months together, because the no wage period shall exceed 1 month. So the wage period means I can give a daily wage allowed. I can give in 14 days I will pay you, it's allowed. I'll give you in 15 days, it's allowed. I give you in 1 month, it is allowed. But if I tell you I'll pay you in 45 days, that is not a salary. It's not allowed under the Payment of Wages Act. Done. So this is the time zone, okay, time gap, that is that within 1 month you have to pay maximum. Then comes section number 5. Okay, fine, I have to pay it for the wage period. I will pay it for one month. Now 1 month is there. Moment the month gets over, I have to pay you. I'll say I'll pay you in some time. I'll pay you. So the law speaks that also, that the wage period must. So this says 1 month will be the wage period. Now once the wage period is over, I have to pay you the money. Do I have to pay you the very next day? Month is over. Does anyone get a salary on first? No. So what does law say? That listen, they've divided it. If you have less than 1,000 employees, or you have 1,000 or more employees. So if a company or any employer has less than 1,000 employees, then he should pay it by the expiry of the 7th day if it are less than 1,000. Okay. Otherwise, in any other case means it will be 10th day. So if he has, here it will be by the 10th and here it will be by the 7th. So every single company you see, okay, mandatorily before 10 they have to give the salary. Otherwise, it is a violation of section 5. Concept clear? And all payment of wages shall be made on a working day. Simple. Now comes section 6. Okay, what a section says? Wages to be paid in coins or currency notes shall be paid in coin, currency notes, or in both. What they are trying to say? Normal, that is the money you will give. Now you either can, now this is an old act. So even coins are allowed, even notes are allowed, but obviously kind is not allowed. Okay. However, the employer may, after taking approval, okay, also give him through check or credit in his bank account, etc. So these are the only ways of paying the money. Deduction. Now I told you this act is not only about timely payment of wages, which we saw, time zone 10th, 7th has to be paid, but it is also preventing unauthorized deduction. So section 7 says deduction from wages of an employee. See, section 7 allows deduction from wages of an employee for the following. So apart from this, if you do any deduction, it is not allowed. It's called as unauthorized deduction. So imagine while paying you, I tell that I'm cutting money for so many things. So they say, no, that is not allowed. These are the genuine things for which you can deduct. So deductions from wages is allowed in the following category. If we have imposed any fine, if you had not worked, if you caused damage, if we had given you an accommodation, if overpayment was done in the last time, if recovery of any, we had given you a loan, we are recovering the loan, if any PF deductions are allowed, income tax deductions are allowed, payment to any society, deductions with the authorization, okay, for insurance premium. So if the employee has taken an insurance and he's told the employer that you can deduct my premiums from here. So all these are allowable deductions. Apart from this, if you do any other deductions, it is a unauthorized deduction. Company has to maintain a register, and every register shall be maintained for entries in that should be preserved for 3 years. Now comes a dispute. Okay. Now all this while was the rules that paid within one wage period will be one month. Payment should be done within 10 or 7 days. Okay, and no unauthorized deduction should be made. Now they are saying claims arising out of deduction from wages or delay in payment, okay, for malicious or vexatious claims. Now claims arising out of deductions from wages or delay in payment for malicious or vexatious claims. Now that means, what is it that the claims that you're doing is vexatious or it is fraudulent claims that has been made. Now let's read. Section 15, that the claims or disputes out of the deductions or the delay in the wage pay also covers penalty on the applicant for filing vexatious claims. Now as we saw in labor laws, we always realize that people are also misusing this thing. So if any workman is misusing, okay, vexatious claims, action can be taken against him. However, any employee aggrieved of any deduction can approach the appropriate authority. The authority, after hearing the applicant and the employer, shall dispose of the matter. He may, on finding that the employer is liable, will ask him to pay. So they are saying that, normally first they will see that employer, they'll ask him to pay. Now they will start with the line, okay. No direction for compensation shall be made if the delay was, bona fide dispute is there, exceptional circumstances there, or failure of the employed person to pay or accept the salary. So no. Okay, so what they are saying is, now normally if the employer was had a bona fide dispute, he can he will not be asked to pay compensation. So he will not be asked to pay compensation if the employer had a proper case. A claim or matter disposed of within a period of 3 months. So 3 months the matter will be done. And however, if the authority on hearing this is satisfied there is either a vexatious or this claim, he may direct the penalty to be paid by the applicant to the employer. Now pay attention, this is just one line. In the start they were all telling that a proper case is there, bona fide dispute, etc. Now they say that the main line of the section, that the authority on hearing an application, if they find that the application was malicious or vexatious, means it was a fraud claim, then they will tell that the workman that what you did was wrong. They'll direct a penalty to be paid by the applicant to the employer. So applicant will have to give penalty to the employer for filing a fake case. Normally they go on to start that any claims is there will go before the authority will decide, etc., which is there, authority will not tell. So this entire section 15 is in the favor of employer, genuine employer, okay. And as per the press release, the government of India has put a wage ceiling. They've increased from, just remember that the wage ceiling here is 24 months. So as a result, more employees will come under this act. So all those who are earning up till 24,000 per month will come here. Okay, so we are not covering all people who are super rich. Up till 24,000 if you are coming, you will come here. So this act is about preventing unauthorized deduction and ensuring timely payment of salary or wages to the employees. So we are done with the entire chapter. Thank you. Okay, now we see the next part of the chapter, which is your Payment of Bonus Act. Okay, so now we are seeing your Payment of Bonus Act. Very simple act also. Okay, Payment of Bonus Act. Okay, which act we are doing? We are doing another act which is called as the Payment of Bonus Act. It is under which lesson? So this is your lesson 18, part 4. Okay, so the fourth part that we are doing, which is about your Payment of Bonus Act. Let's start. So the Payment of Bonus Act 1965 regulates payment of bonus, okay, to its employees. Okay, to its employees. In that they cover provisions such as minimum bonus, that how much minimum bonus should be given, how much maximum bonus can be given. Now why maximum bonus? Because government doesn't want that the employer is also overburdened. So the government said that for a certain workmen you have to give. Now for many years bonus was given as a practice. Now they say minimum you should give this much, maximum we are putting on this much, so the employer is also not overburdened. Okay, then when bonus is, to whom bonus is given, how many years they should work with us, and when bonus can be cancelled, forfeited, or forfeiture of bonus. So let's see. Now tell me one thing, don't you like bonus? So similarly, the government has made that for certain classes of scheduled employment, so in the schedule of the act, they have told to which all industries this apply. The object of the act is to provide bonus to persons employed in an establishment. Now in Jalan Trading versus Mill Mazdar Sabha, it was held that the object of the act is to maintain peace and harmony by prescribing minimum, maximum and timely payment of bonus. Finish. Okay, so why we are giving bonus? So that employee is in love with the employer. Okay, because he is getting bonus. Now the application of the act applies whenever it applies to every single factory, every other establishment where there are 20 or more person on any day in the accounting year. So even if one day 20 or more persons were applied, this will be this act will be applicable, and if the limit goes below 20, the act will still continue to be applicable even if the employee falls below 20. So remember this is a common among all the labor law, that they say that if normally how it happens, average or the last day, they say no, if any day in the last year you had 20 or more persons employed, then the act will become applicable, and once it is applicable, it will continue to be applicable even if you have lesser people now. So it's like a Fevicol stuck. If the act is stuck on you, then every time you have to keep giving bonus to your people. Now eligibility for bonus. Now who is eligible for bonus? So all the now CEO, CFO, director, they already have very good salary. We are not covering them in labor laws. In labor laws, we cover all those poor little people who are having this entry level jobs. So for them we are telling. So eligibility limit of an employee is whoever is earning 20 up to 21,000 per month. So if anyone is earning a wage 22,000, they will not be eligible and not be covered under this act. Simple. So employee here means a person who is having a salary or wage not exceeding 21,000 per month. Okay, simple. Now government, if you read this provision, you will find it very funny, that giving the bonus, mandatory bonus and all of that, this act doesn't apply to the following classes of employees. Section 20, the act is such a good act about giving bonus. It doesn't apply to the following: insurance sector, anyone who's working in the sea, merchant shipping act, dock workers, they're working with the at the docks on the sea only, government affiliated, and these are all government affiliated only. Okay, non-profit educational institutions such as Red Cross, these institutions, RBI employees, employees of financial institutions such as Unit Trust, IDBI, SIBD, NHB, inland water transport employees. Okay, now sir, what is all this? So they are saying that the provisions of Payment of Bonus Act does not apply to all these people. If you see, I want to ask you why. There's a very simple logic to it. That government employees, all those working with the Navy, Merchant Shipping Act, in the sea, docks, insurance sector, RBI, they already have a lot of other perks. If I'm a government employee, I get so many other benefits. Then getting a benefit here is not needed for them. That is why they have been excluded from the purview of this act. So government affiliated employees, they get a lot of benefits. They won't need another benefit. That's why they have been kept out of this act. Now, eligibility for bonus. Now, every employee shall be entitled to be paid by his employer in accounting year bonus for not less than 30 days working in that year. Let's see. Eligibility for bonus. Now, imagine I have a new employee. I have come yesterday only. I am telling, give me bonus today. Everybody is getting salary. Give me also bonus. So they're mad over it. At least 30 work. You should at least work for 30 working days. Then you become eligible for bonus. I say my salary is less than 21,000. What nonsense? Salary is less than 21,000. That's one thing. Up to 21,000, that is you are eligible. But also one more eligibility has been added. At least work for 30 days in a calendar year. Then you are eligible for bonus. Eligibility: every employee shall be entitled to be paid by his employer. Okay. Bonus for, okay, provided he has worked in that establishment for not less than 30 working days in that year. So eligibility for workmen for this, if the employee has worked for 30 days, okay, in that year. So if he's worked for 30 days, he becomes eligible. Now comes disqualification of bonus. Now when you will be disqualified, disallowed to the bonus. Now imagine if I'm supposed to get bonus, I am having up to 21,000 salary and I have worked for 30 days. So I am very happy that I'm going to get bonus, but I will be disqualified from getting bonus if there is a fraud. The employee is dismissed from service for fraud, rioting behavior, riot or violate, one tight slap you gave to the employer. So will you get a bonus from the employer? There is no, because you have done violent behavior on the premises, or you have been convicted for theft, misappropriation, sabotage of the property. Then in that case you will not get bonus. So bonus, you will become disqualified from getting bonus if the person has done fraud, riots, violent behavior, theft. All these cases it will not be given. This is given in your section number 9, because bonus is ideally being given to the employees who have helped the company make profit, maintain stability of the establishment and well-being of the industry. Now comes bonus. Is obviously, as we said, why it is not given? Because bonus comes with obligation of good behavior. Okay, so if a person was not good, he would be disqualified. Now there was a very classic case of project manager ONGC versus Shyam Kumar Singhal. Now here what happened, that there was an employee, he was suspended for allegations of violent behavior. Allegations were there, but later he was proved innocent and he was reinstated with full back wages. Sir, what does reinstated with full back wages means? That means he was reappointed in the company with full wages. That shows that he had not done anything wrong. Allegation was there, but he was not convicted. Instead, he was acquitted. He was free. and so then he cannot be treated to be disallowed for bonus for the period of suspension. So if he was suspended, during that time bonus was given and he was proved innocent, he will get bonus during that time period also. Now by when the bonus should be paid is given under your section number 18. By when bonus should be paid? So it should be paid within 8 months from the close of the accounting year. So bonus should be paid within how much time? Within 8 months from the end of the financial year. So very simple. Let's move ahead. Okay. Now there is a provision of minimum and maximum bonus. Now this is important. Okay, this is important. Very simple. That minimum and maximum bonus. Now pay attention to this. What happens is, let's read. Okay. Section 10. Every employer shall be bound to pay a minimum bonus of 8.33% or 100 rupees, whichever is higher, of the allocable surplus. So allocable surplus means the company has this much money to distribute as dividend. Means they have made a surplus in the business. In business, what do they have? They have a allocable surplus. They have a allocable surplus. So then that surplus means what? Company has made a profit now. So they will get minimum bonus is how much? Minimum bonus is 8.33% of salary. Now when they see the definition of salary, I told you salary includes dearness allowance also. DA means what? What does DA mean? The extra money paid to meet the cost of inflation. So 8.33% of salary or rupees 100, whichever is higher. Okay, simple. So this is the minimum. This much the minimum I have to give. So 8.33% of salary, I'll find out how much it is and I will give you. Okay. Now if a person is 15 years only, then obviously this instead of 100 you will read it as 60. 8.33% of salary or 60 rupees, whichever is higher. Okay. Now I told you it is a allocable surplus, means some surplus is there. Where if an employer suffers losses during that accounting year, is he bound to pay minimum bonus? Yes or no? Is he bound to pay? So it is written he is bound to pay minimum bonus even if there is losses. In State versus Sardar Singh, so they said listen to the full provision that if at any year, now pay attention, this is very important. Okay, if the allocable surplus, we didn't have only surplus, is less than the minimum bonus that we have to give as per the act, which is 8.33 of the salary, then let's say this is 100 and your minimum bonus that has calculation is 120. So we have to give, but we don't have money, so how will we give? So then they said this 20, that is the deficit will be carried forward to be paid up to the 4th accounting year. Till 4 years we can carry forward to give them this bonus. That means in the next year when we make profit, we will have this 20 rupee that we had not paid last time, we will pay it now. Clear? Similarly, the maximum bonus is 20% of salary. So now pay attention. If the allocable surplus is greater than the maximum bonus that can be given. So the maximum bonus also, we'll just see what is the threshold, is 20%. Okay. Here. So payment of maximum bonus. That payment of maximum where the allocable surplus exceeds the minimum amount. Okay. The employer, so we are the surplus is more than the minimum amount and the employer shall be bound to pay to the employee a bonus maximum of 20%. The maximum bonus is 20% of the salary. So minimum is how much? 8.33. Minimum is 8.33 of salary and maximum is 20% of salary. So government has set this limit. Okay, so this is sorted. Now pay attention to this. If at any year, there are two scenarios. The minimum that I have to pay, I am earning less than that. And the second one is maximum what I have to pay, I am earning more than that. So this I told you that if you are earning less, then next year whenever we earn, we'll have to give. So this amount will be carried forward to pay it up till the 4th accounting year. Now, allocable surplus is greater than the maximum bonus. So by law, they have told that the maximum bonus if we calculate is 100. And let's say the surplus company has made a 30-40% profit. So 120 is there, so allocable surplus. So now we have a surplus. We can't pay because the maximum amount is only bonus we can give 100. So this 20 will be also carried forward. This will be carried forward to be paid up to the next 4 accounting years. 4th accounting year. So this guy, all the people will say that listen, this for 20 is ours only, na? We couldn't be gotten this year. Next year, whenever 3rd, 4th. So up till the 4th accounting year, it will be settled. Understood? So if I am earning less than the minimum, then I say don't worry. When I earn, I will give you. I am carry forwarding this amount as a amount that I have to pay you as your dues, and we'll pay it. Now if I am earning a lot, then I will say, listen, I can't give you more. Law is told, because we don't want the employer also to be harassed by the employee. So we set it up. We say 20 rupees whenever next time it is there, we can adjust it. We will give it to you up till 4 accounting years. Okay. That is there. Now just one line remember. Okay. Just let me complete the set of provisions. Okay, and just remember that if bonus in case of new establishment. Now in the first accounting 5 years, the company need not pay bonus for the first 5 accounting years for inadequacy of profit. So one exception has been given for startup companies, or those beginner companies for new establishment. Up till 5 accounting years, they don't have to give. So in the 5 accounting, so section 16 says bonus in case of 5 accounting years need not be given if they don't have profit only for 5 accounting years. In all other cases, we saw that it gets carried forward to be set off in the next years. Now this, remember that the calculation, how it is done. Okay, I don't think they will ask you this calculation, but just remember that if the salary exceeds 7,000, then the bonus will be done assuming that the salary is 7,000 rupees. If it is less than 7,000 rupees, then we will do the calculation based on the actual salary earned. Now pay attention, all those, now just this line, just remember, I want to teach you this and then we'll move ahead. That if, now pay attention to this. Okay, now pay attention that I will catch all those people who have 21,000 people, up to 21,000, I'll call all of them. Let's say I call them all in a room and I say I'm doing your calculation. So in the calculation, what we have done, 8.33% of salary. So I'll ask, what is your salary? So someone will say, so all the eligible people I'll call, 21,000 I've used up I've taken for this calculation, I call everyone and I say, what is your salary? So someone comes and says their salary is 10,000. So I will say 8.33% of salary, but for the purpose of calculation, we'll take 7,000 rupees only. We won't take 10,000 because upper limit has been given for salary calculation also. We don't want to overburden the employer, and then we will do the calculation. So assuming that the salary is 7,000 only. So anyone who's earning 8, 9, 10, 11, 12, 13, up till 21, their calculation will be done as per 8.33% of 7,000 only. But if someone comes and says, I'm earning 6, I'm earning 4, I'm earning 2, so then we'll do 8.33% of the actually salary earned. So someone says, how much you're earning? 5,000, so we'll do 5,000 rupees. So this is the calculation how it is done. When they say salary, what do they mean? 7 or less only. Okay, this is how. Now remember one thing is computation of the number of days. Now when I have to calculate, that he has to work for so many days, etc. So the computation of the number of days, an accounting year, an employee in an establishment is considered to have been worked for the following days. So all these days are considered to be working days. The days he was on paid leaves, the date he had a temporary disablement, maternity leaves, that is also allowed, and laid off leaves also, where the company told him to go back home. So all these will be treated as working days, because you have to see now that he has to work so much to be eligible to bonus. Set on, set off, I told you. Set on means what? That the allocable surplus is greater than the maximum bonus that we can give. So the 20, the excess, okay, the excess will be carried forward up till 4th accounting year to be adjusted. Adjusted what they call it as set on, to be set on. The other way around, we say set off is where the allocable surplus is less than the minimum bonus. Then the deficit that is there will be adjusted in the up till the 4th accounting year, which means they use the word set off. Will be set off in the next, up till the 4th, will be carried forward to be set off in the succeeding years. Adjusted, it means. Now imagine if you are eligible to bonus, or employees are eligible to bonus, and the employer is not paying. Okay, so let's say the employer looks something like this. This is the employer. If the employer is like this, you are unable to recover the bonus from him. So you will now file to the court for application for recovery of bonus. Who will file? Employees will go to the appropriate government, okay, and get a order, okay, within, application must be made within 1 year from when the bonus becomes due. Time limit is within 1 year, they have to go. Then a certificate will be issued, and a certificate of recovery will be issued that the employer has to pay you 10 lakh rupees in total. A officer will be appointed, and he will recover it as a land dues. So he will recover from the collector will come in and try to recover, and then after he'll recover, he can sell off the property, he can freeze the bank accounts, he can do whatever he wants, and they will give to the employees. Okay. Any disputes will be deemed to be a industrial dispute and will be settled as per the Industrial Dispute Act. Okay, we have labor code for this. Okay, now calculation of the bonus, very simple. When I told you, remember, just remember this, that first will be gross profit. Just write down this format and you'll be sorted. Okay, this is not very important for you, but still, gross profit. Remember, we had done allocable surplus. AS we were writing the allocable surplus. How is that calculated is here, allocable surplus. So we are doing calculation for allocable surplus. Just write down, you'll come to know. So first we have the gross profit, sales minus COGS is gross profit. Then from the gross profit we will do deductions. Okay, certain deductions will be done. Allowable deductions are there: income tax, depreciation, direct tax that you have to pay. So minus, this is a format they've given you to come to allocable surplus. Then you'll do deductions for taxes, etc. For taxes, depreciation, etc. Okay, because from the gross profit I need to reduce few more things to get to net profit. Okay, then I will say, then they are saying that any difference between the tax calculated on the gross profit for the previous year and the tax calculated on the current year, then they will say that you have to add. Okay, what will you add? The tax, difference of tax between last year and current year. So last year if I paid 1 lakh and this year I paid 1 lakh 20 income tax, then 20 will be added. Now this is a format law has been given. Okay, that will be done. You will get your available surplus, and allocable surplus is 60% of the banking company is of the available surplus, and 67% in any other company. Now pay attention. Once this is there, gross profit less your deductions, then you get your add the tax difference between last and current year, then you will get your available surplus. So this much surplus the company has. From this they are saying, if it is a banking company, we'll take 60%, and in all other cases, if it's a non-banking and all other companies, then 67% of the available surplus will be your allocable surplus. We had done what was allocable surplus. Allocable surplus is 60 or 67% of the available surplus. How did you get this available surplus? Gross profit less deduction plus tax difference of last and current year. That's it. I don't think this is important for you, the calculation, etc. But still, I've done it. So I've completed the entire chapter. Thank you. Okay. With this, we have completed your lesson number 18 in depth. Okay. Now we'll go to another lesson. Lesson number. Okay, we'll go to another lesson. Let's see which one we'll complete. We'll go to your Industrial Dispute Act. Lesson number 17. Now we are going to lesson 17. We are doing Industrial Dispute Act and Standing Orders. Okay. Now we'll complete your Industrial Dispute Act. This is your lesson 17 part 1. Lesson 17 part 1. Okay. Clear till here? Okay. Okay. We'll just take a 2-minute breather, and I'll come back. Okay. Till that, you can revise your particular Industrial Dispute Act. And Hari is asking the IPC is repealed, so just write as per the BNS Act. Just write as per the relevant provision of the BNS Act. Please, can you share these notes? So let's see. I'll see if I can share. Otherwise, you can refer your existing notes or what you're already referring. So your job, maybe till I just take a breather, you can in 10 minutes I'll return. 10 minutes. Till that, I want you to complete one chapter of part A. Part A, complete 3-4 chapters and be ready. Okay. Okay. So I think someone has asked, there are no amendments in labor laws at all. Whatever amendments is there, I have shared one amendment sheet which is not of labor law, which is of some MSME Act and LLP Act. Okay, LLP Act, they have said that the beneficial owner provision which was there in company law, section 19, the same they've added for LLP also. So any beneficial owner of LLP has to disclose their interest. So that has been done. Okay. Now before I start, I want you all to put in the chat box, I'm audible, visible, so I can quickly start. Okay, quickly everyone. And those who not like the video, please do it immediately. Okay, this much you can do it for me. You can share it to people also. I feel good. Okay, I know that I'm able to reach out to you all and help you all pass your exams. Okay, audible, visible in the chat box, so I can quickly start. EV in the chat box, just EV is also sufficient. Okay. Can I have audible, visible in the chat box? Nobody is replying, at least you message it and close it. So I can start with my lecture. So I know that I'm able to, that you all can see and me, I can't start my lecture without you giving me a confirmation. Okay. Thanks a lot, Pradeep. Thanks. Let's start. Hi. So we start with a chapter called as Industrial Dispute Act 1947. Now this act was introduced. For all the acts we have to write the introduction and object of the act. Okay. And in this act we will also write the case law. Workmen's of Dimakuchi Tea Estate versus Dimakuchi Tea Estate. Okay. So Industrial Dispute Act is an act that provides for resolution of disputes. It provides for resolving disputes between employer-employee, workman-workman, employer-employer, and all of that. Okay. So this entire act is for settlement of disputes. So we'll write the case law, the object of the act. Supreme Court in the Workmen Dimakuchi Tea Estate versus Dimakuchi Tea Estate has said that the object of this act is to ensure that there is peaceful relation between employer and workmen, and settlement of dispute if it is between employer and workmen, employer and workmen and employees, or workmen and workmen. And it also provides provisions for strikes, lockout, retrenchment, layoff. Now out of these four, one comes in the exam. What is a strike, what is a lockout, what is a retrenchment and layoff, which we'll be studying now. Okay. So if they ask what is the meaning of industry, okay, Industrial Dispute Act. So we saw dispute is between who all is covered. The other one is what is an industry? So industry is where, as per the Bangalore water supply sewage versus Rajappa, they have told what do you mean by industry. So industry is a place where manufacturing activity goes on. So industry is a place where any activity goes on, organized for goods and services, and absence of profit motive is that doesn't matter. So industry could still be, if it is a Section 8 company, still it is covered. The true focus is on employer-employee relationship. So for industry, they have told in the Bangalore water supply case is a manufacturing unit or a industry. You have to see these things, whether there is a systematic activity or no. And let me tell you. Now section 2J of the act defines what is the meaning of a industry. So a systematic activity that has been carried out, okay, for provisions of any goods and services, goods or services, both are covered. Okay, whether or not, it doesn't matter whether it is profit intention is there or no, whether capital has been given or not been given. Okay, and all this, and it includes all these things. So it includes docks or any promotion of sales. Everything is a industry, but does not include all these things. Now these are not industries. Agricultural operations is not covered, hospital is not covered, educational institution is not covered, khadi village is excluded from the definition of industry. Now very important is what do you mean by the term industrial dispute? So industrial dispute means a dispute between all this. We saw it was given in which case law? Which case law? We had done it above. Dimakuji tea estate. And always workmen, when they say workmen, includes temporary, skilled, trainee. So workman ideally means a person who is employed in the industry, whether be skilled, etc. Includes any person who is dismissed also. So who has just been removed, even he is a workman. He can also file a case in Industrial Dispute Act. Okay, but does not include the word workman. Now normally workman definition not important, but for definition of Industrial Dispute Act it is important. So it does not include anyone who is from the Army, Navy, Air Force. So anyone working in the Army, Navy, Air Force cannot file a case. Police, all this is fine. But even this is saying that a manager who is there, a person who is having a managerial role, is not covered under the Act. Okay. So we say employee, employer, manager is not covered. Manager or who has a managerial or administrative role only will not be covered, or anyone who is doing a supervisory work and drawing a salary of more than 1600 per month is not covered under the definition of workman. Workman means manager will be supervising a workman, right? So that is a workman. So who the manager supervises is the workman, what they are trying to say. Now I told you that the object of the act in the Dimakuji tea estate have said that it is to have peaceful relations between everyone and make provisions for 4 things: strike, lockout, retrenchment, layoff. So let's see, what is strike? So strike we know is a cessation of work. So the work is stopped by employees or workmen, by a group of employees. So one person cannot do a strike. A strike for them, it means a body of persons employed. So who are saying that they will not do. Okay, in combination, all of them collectively are refusing to work and they have not left the job. They refuse to continue to work. Okay, so it is the termination of it doesn't include termination of employment. It is a kind of one. And why are they ceasing to work? Because they must be having they are doing a collective bargaining. So strike is a weapon in the hands of the workmen to bargain from the employer. They will say we'll go on strike if we don't give us bonus. So it's an example of strike. So strike, what do you mean? It's a cessation of work by persons employed in combination, and they are refusing to do the work till their demands are accepted. And it does not mean that they have terminated the employment. Simple. Now, strike could be of multiple kinds, and just simple headings we can do is enough. So either they sit down in the employee, they put their tools down, refusing to work. The other method is to go slow, where a person is not happy, employees are not happy, then they are not working as per the normal speed. This causes damage to the machinery also. Then comes a sympathetic strike. A sympathetic strike is to support some other employee. Okay, you are doing a strike. Maybe if the employer has slapped one of the employees, in his sympathy in support of demand of another workman, everyone else is also striking. Work to rule is also one thing where the employees are working. Now this is a very rare case that they will say we'll work so hard that the employer will realize his own mistake. This is somewhere how Gandhiji has taught that if someone slaps you, put your other face ahead. Okay, so here what you are doing is, if employer is not listening to you, you work so hard, don't talk to them, keep working and prove your worth so that he gives you a salary. Hunger strike is they resort to fasting near the place of the residence of the employer or the work. So these are all methods of strike. Now in Gujarat Steel versus Gujarat Steel Tubes, whether the justifiable strike is a purely matter of facts. Whether a strike is legal or no depends on facts of the case. Whether if the demands are genuine, the strike is legal. If it is a legal strike, salary will be given during the time of striking also. Okay, so if the strike is done to meet some bona fide demand, then the strike is justified. Using violence, then strike is not justified. Okay. Then comes, I told you 4 things are there: strike, lockout, retrenchment, layoff. Second is lockout. Lockout is what? In case of Maruti, what happened is the company was like, the employees are not listening only to me, I'll shut down. So temporary closing of workplace, suspension of work by the employer. Employer is saying, I don't want to employ you all. Okay, I don't want you all to work. You all are not listening to me. So this is a collective bargaining in the hands of the employer. So when the employer, so how sometimes the teacher says, I will not teach you all now. You all are making so much noise. So when the classroom is making noise, the students are not listening. So the teacher gets angry. So this is like the employer is getting angry. He is refusing to employ. He is closing down the employment. He is not removing it. It is not a termination. It is just the opposite of strike. Lockout is in the hands of this. Okay. Here he is refusing to say that no, I don't want you all to be there in the company. There is a dispute. Okay. Then comes, so strike is refusing of work, cessation of work by employees. Lockout is basically refusal to employ by employer. Layoff is basically, if for layoff means it is not a removal of employees. It is just that due to business reasons you cannot employ. So due to business reasons you could not employ the person for that day. So you remove him, you lay him off. For example, if there is no SAM, let's see if it is no SAM is fitting. I learned a code word during my examination. Okay, so no SAM. So if let's say there is an earthquake, natural calamity, there is a natural calamity, will we tell everyone to work? No, go home, don't come. That's a layoff. So layoff is a inability to employ due to some reasons. Inability means even if I want you all, I am happy with you all, but I can't apply because there is an earthquake going on. Then O is for any other reason, simple. S is for there is a shortage of machinery. Raw materials are only not there. A is there are so many raw materials that the entire godown is filled, office is filled, so nobody can work. Accumulation of stock. And last is there is a breakdown of machinery. So beautiful code word I have made, no SAM. So there is an inability to employ. It's not a termination. It's just during that time where layoff is there. It's due to this reason. The inability to employ due to the following reasons. No SAM. Then comes difference between lockout and layoff. In layoff, due to business reasons, the employer cannot employ. This is due to any action as a collective bargaining to teach the employees a lesson. The lockout is done. So there it implies a dispute. Normally in lockout there must be some dispute, that is why it is happening. In layoff there is no dispute. Then comes retrenchment. Nowadays you must have read in the newspaper so many times that company XYZ has, due to AI we have removed this one, that one. So retrenchment means the termination by an employer of the services for a workman for any reason other than by way of punishment. Means due to let's say my company has purchased or is implementing or is introducing a manpower software. A manpower software means this does the work of 20 employees. So once I put the software, then I don't need the employees, right? So I will retrench them. Now did they do anything wrong? Answer is no. Were they retired? Answer is no. But for reasons other than disciplinary action, other than retirement, I am removing them. Okay, so here this is the first time when we are reading, it is a termination of employment. We remove him from the service for any reason whatsoever other than by way of punishment. Okay, which is inflicted by this and does not include retirement. This is voluntary retirement. Superannuation means compulsory retirement. So age is given, that time it is, so that all is not included, right? It's not due to retirement or this or ill health. It is genuinely we don't need you anymore, is where retrenchment comes in. So in retrenchment there is a termination by the employer, not result due to disciplinary or retirement. Okay. Now employer employee, when they have a dispute, normally they go through a conciliation process. They go through a conciliation process where a conciliator is appointed to resolve the disputes. He interprets the issues, he tries to bring in the settlement. Now he will tell the employer also, give them the security, and they'll tell the employer, don't ask so much. In the industry nobody gives, so they try to lower the tension, make a amicable settlement. So when a amicable or mutual settlement is arrived, between whom? Between the employer and workmen. Between the employer and workmen, then they reduce it in writing. They mention this settlement agreement in writing. They get it signed by the parties, and they give it to the conciliator officer will give it to the court, and then the matter will be dismissed. So two things are there in settlement agreement. One is settlement agreement has arrived in a conciliation proceeding. So someone was appointed and they tried to settle the matter. Written agreement was there. Okay, and after that, the court will be submitted to court that this we have settled it and the dispute has been settled. Okay. Now, various authorities under the Industrial Dispute Act have been set up. Now, common sense. If there is a dispute, we require adjudicating bodies, we require deciding bodies, we require deciding or adjudicating bodies. We call them as court, right? We call them as court or tribunals. So tribunals are your industrial tribunals, etc. Labor tribunals, labor courts are your. But before it reaches to the court, also there are multiple people who are involved. We saw one already. Who we saw? Above we saw a settlement agreement. Who gets it done? Conciliating officers. Now if you want a conciliating officer, you can go to the board of conciliation who has a panel of all these conciliators. Okay, let's see. So works committee. First we come with the works committee. Now in a company, the appropriate government may by order require the employer to constitute the work committee where 100 or more people are working in any of the days in the past 12 months. Duty of the work committee is to promote amicable settlement and comment upon matters on common concern. Very simple. So works committee, if the government wants, they will tell to set up this committee to bring in a amicable settlement between good relations, promote good relations among the employer employee. Done. Conciliation officers movement are right. You know what is conciliation. It is conciliation is a method of resolving disputes with intervention of third party. They try to resolve the disputes by bringing a amicable settlement, and then you can write about. Okay, so a board is constituted of this. It will consist of a chairman, and they will make rules for conciliations, etc. Court of inquiry can be appointed to inquire into matters and concerns of industrial dispute. Okay, they will do evidence finding, etc. Labor court is the proper court where orders have been given. They will hold proceedings and pass orders. The order of any court or tribunal will be called as award. What you will write? Award. Okay. Now remember one thing is public utility service. Market is important. Normally any kind of establishment, any kind of business which affects you and me for the day-to-day business, you and me both require this service. Is called as public utility services. So public utility services means it is a service used by public, you and me, like electricity, like railways, like post, like docks, like light, water supply, public sanitation, okay, public toilets, etc. Now these are all public utility services. Now in public utility service, let's say for example bank is a public utility service. Bank wants to go on strike. The employees of a bank, or the employees of a railways, the employees of docks want to go on strike. So they made special rules that if any of the employees who are working in a public utility service, they want to go for strike, then they cannot just go for strike. They have to follow some rules, because see, any private company who can go tomorrow also for strike. No law is mentioned for that. For public utility service, special rules are there because it affects public at large. Railways, docks, post office, light, water, public toilets, etc. We will see what are the rules when we come to it. Now, strikes and lockout. Okay, now pay attention to this. Strike and lockout, you can give the definition. Now remember one thing, that general prohibition for strikes and lockout means no workman should go for strike and no employer should declare a lockout. If following, this is common for both. So these are general things, that if any conciliation is pending, any court order is pending, any arbitration proceeding is pending, or any settlement order is in operation, means anything is pending. So if, see, they are saying during a case, in a court case is going on, don't go for strike. Court is there now, they will decide. So there is a pendency of a conciliation proceedings or a arbitration proceedings or a settlement proceedings is on, or labor court proceedings are on. So when case is going on, don't strike or declare lockout. So when a case is on or pending, don't declare strike or lockout. Concept clear? Simple points that is there. Now, prohibition. Now I told you, general prohibition is there that everybody, persons of every this, if there is a pending court case going on, don't strike. Pending arbitration, conciliation, labor court case, don't strike, is a general prohibition. Now in section number 22, they talk about prohibition for certain additional rules for public utility service. If anyone is like electricity, from where you get electricity, so they are dealing in public utility service, they can't go and strike. From where you're getting water, municipal body, so they cannot just go on strike. They have to follow certain rules. Why it is there? These rules are there to prevent possibility of public inconvenience. The rule why we made that for public utility service, strike or lockout, you should not go. Special rules have been made to prevent possibility of public inconvenience. Like they have told you, very simple. First, no person employed shall go on strike in breach of, during the pendency, as we saw, it was a general thing. Okay. Then before the date of strike specified in any notice. So if they are giving any notice to the employer, so before the date, for example, if I say I'll go on strike, they write, employees write it to the employer that I will go on strike on 25th September. So I cannot go before that. So no person employed, means no person employed shall go on strike during the pendency of any conciliation. This was a common rule only. Before the expiry of the date of strike given in the notice by them, or without giving a notice to the employer. Okay, so you cannot go without going in notice, and within 14 days of giving such notice. So without giving a notice I cannot go. I give the notice within 14 days I cannot go. Okay, before the expiry of the date specified in the notice or any conciliation. These many points you can write at least. Okay, similar points have been given for lockout also, that without giving a notice they cannot go, within 14 days of the notice they cannot go for lockout, before the expiry of the date specified for lockout, and during the pendency of any case. Now imagine one thing, if a strike, let's say, remember this, that if the strike is legal, has been proved by court it is legal, or if the strike has been proved by court to be illegal, you tell me, salary or wages will be paid or no? Salary or wages will be paid if the strike is legal. During the period of strike, will salary be given? Answer is yes, because strike was legal, employees were justified, so they will get salary. If it was proved by the court that the strike was illegal, then during the period you had done the strike, you will not get salary or wages. Now similarly, you tell me, if the employer has declared a lockout, he's saying I will not do till you do this, and it was proved by court that this lockout was legal, or it was proved by court that the lockout was illegal. Then if it is proved by court that the lockout is legal, will salary or wages be given? If lockout is legal, means employer was correct, so salary or wages will not be given. If the lockout was proved that is illegal, that means the employer was wrong, therefore salary will be given. Clear? So wages or salary will be given accordingly. Okay, penalty they have given, you can learn the penalty, you can quote it in the exam, that if it is a illegal strike, okay, imprisonment can be given up to 1 year or a fine of which may extend to 50 rupees or both. So this section also you can learn, at least if you can't remember, you can at least write section number 26, very very important. So you can always write that in case if it's a illegal strike or this, penalty under section 26 will be given. Now unfair trade labor practices. What does unfair trade labor practices mean? Doing all this is wrong. Threatening someone from removal, threatening a lockout, threatening a strike, threatening someone to join a strike, using violence. So these are all unfair labor practice on behalf of employers. Okay, discharging or punishing a workman. So all this is wrong on behalf of the employers. Threatening a workman if they join a trade union. So threats cannot be given. Similarly, workmen, if they do this, it is unfair. That they are telling to support an illegal strike. So if they tell anyone to support an illegal strike, it's wrong. If they demonstrate outside the employer's house, it is harassment. If they do damage to the property or violence to the property, or they force anyone to join the trade union, these are all wrong. If they instigate anyone to take violent steps, coercive steps, then it is unfair on the part of the workmen. And with this, we have completed the entire chapter on Industrial Dispute Act. Thank you. Okay, now we see the next one is after Industrial Dispute Act, there is a Standing Orders Act also. Okay, Standing Orders Act. Okay, part 2 is standing orders. So very very simple is standing orders also. Okay, let's see. Let's understand what is Industrial Standing Orders Act 1946. So basically what used to happen is, prior to this act there was huge exploitation on the workmen, where what used to happen that employers used to employ the workmen without written agreements. You tell me that when an employer is there, okay, he will hire all these workmen. You think they will enter into very big contracts with workmen who come on daily wages? What a contract they'll enter, but they can't read and write only. So no contract was made. Therefore, they could be removed anytime, and no conditions of work was also given. So all the terms and conditions used to be heavily, or they would even make them sign hypothetically, then it would be heavily in favor of the employers also. So what did the law say? That in order to make the conditions of work clear and not make it unfair, they have made something called as standing orders. So standing orders are nothing but rules and regulations, or I could call it as terms and conditions for work. So there are two kinds of standing orders, pay attention. So one is standing orders are the rules and regulations, or I could just write terms and conditions for work. Okay, now there are two kinds of standing orders. One is called as a model standing orders. Model standing orders are if any employer doesn't have a written agreement, then automatically by default the model standing orders will apply. So these model standing orders apply by default. Okay, if no agreement is there. if any agreement is giving any terms and benefits lesser than model standing orders, still model standing orders will apply. Means this is the bare minimum. This is the bare minimum terms and conditions that are there, which the employer has to give. So with this, what happens? We have created a uniformity, clarity for all those where agreements have not been entered. Now, but if we come like a company like Tata's, they say that we give better terms and conditions than the model standing orders. Then what will happen is this will be called as certifying standing orders. Certifying standing orders are approved standing orders by whom? By trade union for the employees and even a officer, labor officer, where the labor officer will see that, listen, are these standing orders with the company is giving, are they more beneficial? If it is more beneficial, then the labor officer will certify it, will approve it, and then this will apply. So certifying standing orders have to be more beneficial than the model standing orders. That's it, and topic is over. Let's see. Okay, what is the object of the act? Why do we make these terms and conditions? Is to create a uniformity of the terms and conditions, have a formal declaration and clarification of the conditions of work. And since it is written, okay, since we have a written this being written, they cannot be altered, changed, etc. Okay, now when does it apply? Same thing, you see that wherever 100 or more are there on any day in the previous 12 months. So almost all the acts have this, that any day in the past 12 months it is there, then this act will be applicable, and once it is applicable, it will continue to be applicable. Okay. So who is the certifying officer? I told you is the labor officer or labor commissioner. Now what is the procedure for certification of draft standing orders? Now what are we doing? We are doing the certification standing orders. So if I prepare the draft, I give it to both the parties. So a draft standing orders will be prepared. It will be approved. It will be approved by what? It has to be, the officer will look whether it is fair and reasonable or no. The certifying officer will look into the reasonableness and fairness, whether it is more beneficial than the model standing orders. Then consent of the employees will be taken. Okay, procedure to be followed. So I'll just tell you how it is. Okay, just write it down and you can frame it in your own words. First, we are talking of certifying standing orders. So what is the process? What is the process? So first you prepare the draft. You prepare a draft certification standing orders. Then that draft will be verified by labor officer called as certifying officer. This labor officer, if he is satisfied about the genuineness of this thing, he will give it to the trade union. Trade union will also approve. Then it will be published. And it will be put up in the language of the the workmen, majority of workmen, and will be put in a conspicuous part of a place also. If any person is unhappy, they can go in appeal, okay, within 30 days to the higher authority, to the appellate authority. Okay, date of operation of the standing order. So when this certifying standard of orders will apply, will come into date within 30 days from the date on which it has been authenticated and sent to the employer. So within 30 days when it has been authenticated and sent back certifying, then it will become applicable. A register will be maintained. It will be posted. This entire standing orders will be posted in the by the employer in English and in the regional language understood by majority of the workmen. Okay. Can you modify the standing orders? Answer is employer is prohibited from making a unilateral modification. You can only do it with the consent of the employer and the workmen. Simple. Okay, and the modification also will not take effect until 6 months from the last modified. So whenever it was last modified, 6 months it will stay. Only after that it can be modified again. So once modified, then 6 months you have to wait to make a new one. Now comes to a very important point. Section number 10A. I want you to learn the section also. Payment of subsistence allowance. Sir, what do you mean by the term subsistence? Subsistence means living, to in order to live, basic, that I will be able to survive, surviving allowance. Now this is applicable when a person is suspended and an inquiry is going on. He will be entitled to subsistence allowance. Okay, understand that if a person there is a inquiry going on, and due to the inquiry he has been suspended. Now during the period of suspension, will he get salary? Yes or no? If a workman has contravened any of the rules, okay, an action is being taken against him, if he is suspended, he will be entitled at least to a living allowance. So how much it is? Pay attention. For the first 90 days of suspension, for the first 90 days, he will get 50% of his wages, and beyond 50 days, beyond 90 days, he will get 75% of his wages for the remaining period of suspension if the delay is not due to him. So for the first 90 days of suspension, he will get 50% of wages. Why? Because at least he will be able to run his house, and after that he will get 75% of wages till the inquiry is completed. Now what all normally matters to be stated? Now many times they ask in the exam, what all are the contents of standing orders? What all does it contain? Now, terms and conditions. Just remember that you go for a job offer letter, what all it will contain. Okay, it will be contain classification of worker, whether description, whether you're permanent, apprentice, you're a employee, you're a supervisor, your role will be mentioned. The working hours, holidays, wage rate will be given. How many shifts you will be mentioned. Leaves with respect to termination, rights and liabilities. Okay, attendance, what time you have to enter. Okay, if any issue is there, how you can redress. All these matters will be stated. Okay, with this we have completed the entire chapter on standing orders. Thank you. Okay, so we have completed your lesson number this also. Okay, has also been completed. Now we just go to another chapter and complete it. Okay, lesson number 16. We'll start with lesson 16 and complete. Okay, so in lesson 16 we are first completing the contract labor part. What are we doing? We are doing lesson 16 part 1, right? Okay, your contract labor. So we'll just come back in 5 minutes and complete. Okay, so we start with the second part. Okay, just write AV in the chat box so I know that I'm audible, visible, so I can quickly start. Okay, so whenever you get breaks, I expect you all to knock off chapters from part A. Okay, just write AV in the chat box. AV in the chat box quickly. You write AV, audible, visible. I know you can hear me, so I can quickly start. Okay, if others mention or don't mention, you take it on your responsibility to just put it in the chat box. Okay, just waiting for any one of you all to reply. Okay, chalo. I'll start. Okay, so we start with lesson 16, which contains one of your chapters, which is called as Contract Labor Regulation and Abolition Act. Let me tell you what is the concept first. When there is a principal employer, there is a principal employer. Okay, could be a person like Ambani. When he appoints a contractor, these contractor have their own people. This contractor employs certain workmen. Okay, appoint some workmen or workers. These workers which are employed through a contractor are called as contract laborers. They are called as contract labor. Now, who is a contract laborer? A person who has been appointed through a contractor. So, any person who is appointed through a contractor is called as a contract labor. This act regulates them. They are the lowest in the hierarchy. So, what does law say? That listen, if any this contract laborer should get proper latrine services, drinking facility, first aid kit, etc. They should get their salaries, etc. In case if the first responsibility is through the contractor to give latrine, drinking, first aid, other services to the contract laborers. If the contractor fails, then the secondary liability is of the principal. So then if let's say the contractor is not paying, normally it happens that these contractors don't pay the contract labor, then the contractor will pay, and since he has made the payment, he will either deduct from contractor or treat it as a loan given to the contractor and then recover from him. So if the contractor is not paying, then the principal employer will have to pay. So we ensure that the contract labor at least gets his salary. He will give, and then the employer will tell the contractor, listen, what nonsense, you didn't pay them, because of that I had to pay. So I will deduct that amount from your payment or I will treat it as a loan. Okay, so this is between principal and employer. Law in certain establishments, certain sectors can even say that you cannot employ contract laborers, or government can also say that if anyone is employing contract laborers, they have to get a separate license and government will regulate it. Okay, so they will know how many contract laborers are being appointed. So the entire thing, this entire act, contract labor, the purpose is to regulate the employment of contract labor. Okay. Normally, in the case of Gamut Limited versus Union of India, it was held that to prevent exploitation of contract labor and improve their working condition, this act was made. It applies whenever there are 20 or more workmen in an employed on any day in the preceding 12 months. If this act is once applicable, then it will continuously be applicable. Now, who is a contract labor? A contract labor is deemed to be employed, okay, if they are hired through a contractor. So the definition is, If a person is hired through a contractor, that person will be called as contract labor. Meaning of contractor: contractor is a person who takes the contract on behalf of a principal employer and appoints contract laborers. Okay, simple. In building, constructions, etc. they have. Now the question is that what is the obligation of the contractor and the principal employer? Means the contractor is there, so he should give canteen services. The contractor will be liable to provide canteen, restroom, toilet facilities, first aid services. The primary responsibilities of the contractor: on failure of the contractor, the principal employer becomes liable. Okay, then obviously the principal employer can recover this amount from the contractor by way of deduction from the amount payable to the contractor or as a debt payable to him. Okay. In Steel Authority versus National Union, there is no provision in the Act which requires a principal employer to absorb the contract laborer as a regular employee. Meaning in this entire Act, we are not telling that the contract labor has now have to be employed by the principal employer. They are not saying that. They are just saying that if the contractor is not paying, then you pay it. That's all. Okay. Now the government can make certain advisory boards. Central advisory board will advise the central government, and state advisory board will advise the state government with respect to contract laborers. Okay. Then now registration as a contract under the Act. Every establishment, as we saw, where 20 or more persons are employed through a contractor, have to get themselves registered. So any establishment, let's say there is a building being made, they have to get registered under here, because contractor will be hiring more than 20 such persons. Okay. Registration fee will be there. Application will be made to the registering officer. Okay. Section 8 says if the registering officer is satisfied that if there is a misrepresentation or any suppression of fact, he can revoke the license also. Simple little point. Okay. Now there can be an inspecting staff who will enter into the reasonable premises, will look into the conditions of work, will seize any copy, will take action as if deems fit. If any person is aggrieved, they can go and appeal to the appellate officer within 30 days. Okay. With this, we have completed the chapter of contract labor. So contract labor are protected under the Act by imposing duty on the contractor, and if he fails, on the principal employer. That's it. Thank you. Now we go to the next act under the chapter. Okay. So which is the next one? Let's see. We see your Child Prohibition Act. Okay. So now we'll be seeing your Child Prohibition Act. Very, very simple act also. Okay. Now we're seeing the Child Labor Prohibition and Regulation Act 1986. Now, can I appoint a child? A child is a person who is below the age of 14 years. Okay. Can you employ them? So this act covers that Child Labor Prohibition and Regulation Act. Okay. Now, as per the Constitution, you will write your 3 articles. 3 articles you should write. Article 24, 39 and 21. With respect to children, there are 3 articles that are there. First is Article 24, which says of the Constitution that no child should be employed below 14 years in any hazardous employment. This is given in Constitution. Article 39 says that it's a directive principle of state policy, that the state should direct its policy to ensure that children are not misused or abused and not forced due to economic activity or to enter into occasions which are not suited for them. And third, Article 21A says that it is the duty of the state to provide compulsory and free education for all the children below the age of 6 to 14 years. Okay. So 3 articles, obviously we've done Constitution, so we can mention 24, 39 and 21A. Mandatory, you have to quote it in the exam. Now, Now my question to you directly, I'm sure you'll get it wrong. Can I employ a child? Yes or no? Can a child below the age of 14 years be employed? Yes or no? Yes or no? So the answer is yes. You can employ. There is an exception only in two cases. So section 3 says that no child shall be employed in any occupation or work except, this is allowed. If you see all children, they are actually working on all these TV ads and all these Dance India Dance and all those stuff that comes, right? Indian Idol. They do work, right? But they are below the age of 14. So that is allowed. So two things are allowed: family business and in entertainment industry. So a child is allowed to be employed only in two places: family business and entertainment industry. Apart from that, they cannot be employed. And now you've seen that the children from this younger age, they are winning all these shows and doing advertisements and earning a lot, okay, through ads, etc. You see this child, okay, he's earning so much money due to the advertisements, okay. So maybe more than a company secretary, chartered accountant, MBA. The moment they are there in this thing, okay. So pretty happy, but we'll be studying for our examinations, okay. Now, and one point they have said that no matter what, no work of your two businesses are allowed, right? Entertainment industry or this. So no work should affect their school education is what they have written. Okay, simple. Now, your prohibition of employment of adolescents. Now we talk about a little bigger. So a child cannot be employed in any work except for two cases which I have told you. Now we talk about adolescents. Sir, who is an adolescent? So they are above 14 and below 18. So just know the age first. Adolescent is basically below 14 and below 18 and above 14 years. Okay. So what they have told that no adolescent should be employed in hazardous occupation or processes as set in the schedule. So then we'll go and see in the schedule that what hazardous occupations they have given and what hazardous processes they have given. Okay. So what is section 3A? That no adolescent should be put into hazardous process or occupation. So they have given such as working in mines, inflammable explosives, hazardous processes, etc. Okay, that is there. Provided no night shift can also be given to an adolescent to be working in excess number of hours. What is there? The period of hours that has been fixed is no period of hours for them no shift should be exceeding 3 hours. More than 3 hours, so one shift cannot be more than 3 hours, and once a shift is being given, then 1 hour break is given. So no period of work shall exceed 3 hours. So no period of work shall exceed 3 hours. Okay, and after that they will get at least 1 hour break. So this also is very simple. Then, and in no day, so they can still work again, but shall never be more than 6 hours on any day. So max 6 hours in a day. So let's write it. So here we'll note it down. Okay. So this section stipulates no adolescent shall be worked in the night. So after 7 p.m. to 8 a.m. this is in the night, not allowed. They cannot work overtime. They shall be required to permitted to work in any establishment on any day in which he has already been working in another establishment. So that is allowed. No adolescent shall be required to work. So basically, if he is already working in one establishment, then he says, I can work 6 hours, then I'll work in another establishment another 6 hours. So that is also not allowed. So no adolescent shall be permitted to work in any establishment if he has already worked on that day in any other establishment. Means on same day he wants to work again, not allowed. He will get 1 weekly, 1 whole day off he should get. Notice should be given. So whenever an occupier is a person who has control over the factory, is employing any adolescent, he has to send a notice to the inspector within 30 days that I am employing this person, his name and all the details. The register will be maintained, penalties are being provided, and that is it. We've completed the entire chapter. Okay. Now we look at the next part, the last chapter in the league is your lesson number okay, your lesson 16 part, the last part, which is called as your Factories Act. Okay, so now we are doing Factories Act. Now we are doing Factories Act. Okay, simple. Okay, so let's see. So now we start with the Factories Act. Factories Act is a act that regulates welfare, safety and work conditions of persons working in a factory. So in this part we will see what is a factory. If it is a factory, this act will be applicable. In the factory they will be telling how we can give safety, welfare of all the people working there. Then they also say that who all can be employed and what will be their terms of leaves with respect to factory. So this is the important parts of the chapter. Let's start. So any act that comes in, that comes in for labor law, you can write that it is a labor welfare legislation. It is a legislation for the working for the welfare of the labor, for the laborers. The main object of this act is to provide adequate safety, health and welfare of the workers, and also make provision for employing women, persons and their annual leave. So the entire chapter is contained into this only. Okay, and also you can write any act that comes in, you can write that this act is administered by the Ministry of Labor and Employment. Let's see. Okay, for this act consists of 120 sections and 3 schedules. So the first schedule talks about the list of hazardous substances. List 2 talks about certain the permissible chemicals, that is their levels, and the third is about certain occupational diseases. You don't need to learn this, but we just saw the chapter what we are studying. The first important part is that this act applies to factories only. So what is a factory? A factory is where a manufacturing process is going on. There will be a premise, a place, location, including the presence, means including the walls. There should be 10 or more persons working on any day in the past 12 months. If power is used, if the business requires power, electricity on a heavy scale, then 10 or more, that will become a factory. Or if it is without the aid of power, then 20 or more working on any day in the past year. Means for a factory, what are the essential requirements? First, manufacturing process. For manufacturing process, you will require a place. So it should include there must be a place, premise and number of people. So 10 with aid of power and without aid of power 20. Okay. Manufacturing process means what? Converting raw materials into finished goods. It could include changing the character of the goods. The goods character will change. For example, in a manufacturing there will be packaging, pumping of oil, generating of all of this, preserving in cold storage. All of this has been deemed to be a manufacturing process. Okay, so manufacturing process relates to any article, oil, all of this, power, printing, ship or cold storage. Okay. Now I told you what is the definition of adolescence. So adolescent, for the purpose of this act, now pay attention to this. Okay, I want very, very clear attention of yours. For the purpose of Factories Act, child is a person who has not completed 15 years of age. Normally we always read 14, right? Only for the purpose of this act, child is a person who is not completed 15 years of age. And adolescent means who is completed 15 but not completed 18 years. Okay, and young person, when I say young person, means what? He is either a child or he is a adolescent. So is either a child or a adolescent. Clear? Done. Let's move ahead. Occupier. Sir, what do you mean by occupier? Now I want you to write it down. An occupier is a person who has control over the factory, day-to-day affairs of the factory. So they are called as, see, Mukesh Ambani is there, he is the owner of the factory, but he doesn't have day-to-day control over. So occupier is a person who is responsible to ensure that all the act is followed. Normally they say that the one of the directors should be appointed as a occupier. Okay, that is there, that only a member of the BOD can become the occupier of the company. Okay. Now, in the act, they say that there should be certain agencies. Now, what are these agencies? They will help ensure that welfare, safety, and one more word was there: welfare, safety, and good working conditions are being given. So, us inspecting staff. So, whenever they will come, they will inspect young persons if they are working, whether the work is being done properly or no. Inspect the documents of any young person, they will inspect documents, etc. Certification agents, they will certify whether a young person is fit to do the work or no. Now, wherever numbers have been given, it is important. So, mark this as important, okay? So, in a factory, whenever there are 500 or more, you have to appoint a welfare officer. And whenever there are 1000 or more workers employed, you have to appoint a safety officer. So at 500 we'll appoint welfare officer, at 1000 we'll appoint safety officers. Okay. Notice by occupier. So moment a person has been appointed as an occupier, within 15 days when he is appointed as an occupier, he is to inform the officer. He has to inform the labor officer. Okay. What is the duties of the officer? To ensure that all the act is complied, safety, health, and all the measures of the act has been done, proper instruction has been given. He will supervise the young persons. He will give a accident report in case if there is any accident in his place. Okay, now we come to one small little part which they can ask you. Measures to be taken by factories, for three words are there: health, safety, and welfare. Health, safety, and welfare. So it should be clean. Okay, all these given you. Wherever you see numbers, you have to remember that there should be a proper disposal system. There should be proper ventilation in the factory. There should be proper dust and fumigation should be maintained. Proper artificial humidification should be done if it is affecting the humidity. Overcrowding should not be done. Lighting should be proper. Drinking water should be provided. Latrine should be given. Okay, then we have canteen services should be given. Spittoons or basin should be given. Now, in the act, beautifully they have done a great job in the module to summarize all this. Summarize, okay? So you can just read the summary and then you don't have to read anything else. From here, you just see wherever the figures have been given, that is important. Okay, they have to wash in 6 months, paint in 3 years. From here, you can remember overcrowding. So all this they have summarized. Wherever you see a figure, you can remember this. Okay, men and women should be having separate load. This, so this measures you can remember. It is for cleanliness you have to ensure. Similarly for safety purpose also, they have to fence the machinery. They have to give proper goggles for protection of the eye. Safety officer, we saw welfare officer 500, safety at 1000. Lift should be in proper conditions. Now welfare is washing facility, first aid facility. Now all these figures are there, they have summarized it. We'll do. Canteen should be given when 250 or more are there. Important. Rest room should be given whenever 150. Crutches is for children. Smaller children, they are there for the small children, infant play area. Welfare officers. So that summary you can do. Okay, summary in that is important. That the numbers we'll see that where 150 or more workers are employed, they should make restroom facilities. Or note it down. Whenever canteen is there, 250 or more persons are employed, they have to give canteen services also. Then first aid box has to be provided for every 150 workers. That is it. Okay, with this we have completed the entire chapter of Factories Act as well, and we've completed your lesson number 16 also. Okay, this is your lesson number 16 also we have completed. Okay, great. Now only these small little chapters are there. Okay, you can just read it up. Okay, you can read it up from the dream batch. I've given you all access to it. Once you understood the flow, all the balance also can be easily done. Okay, so wish you all the very best. Complete the balance part. You'll be able to complete it really fast from the dream batch. Given you all access. The links are in the description of the video. That is it. Wish you all the very best. Request you all to go ahead now only and complete it. Okay, thank you guys. Take care. Bye. Okay, take care guys. Complete full part B thoroughly, where you can get 40 marks. Okay, out of 40 you can get 30 marks. Then in part A you have to pass. Normally students panic out. Remember that this is your lifeline. Part B is your lifeline. From part B, if 40 marks you can manage 30 marks, you are sure to pass. Just remember this. If from 40 I can get 30, I am your 110% passing. So best job is to do this. Okay, so you can refer the module for the notes. Okay, I am mostly covered from the module only. Okay, and in the dream batch you download our app. In that there's a dream batch for executive. You can go ahead. Even if now you enroll, it will still be beneficial, because in that there's a discount coupon specially for y'all. Okay, where you get 1,000-2,000 rupees off. Okay, that is it guys. Wish you all the very best for your examination. I will see you all tomorrow again with the GST marathon. Take care. Bye. And do like the video. Okay, thank you.